Okay, thank you for coming today. Welcome. Today's the Interested Parties meeting. And we'll start off with a few introductions for those of you who do not know us. I'm Kurt Warden. I'm the Chief of Licensing. To my left is Kurt Hefter, Legal Counsel. Next to him is Anita Scurry, Legal Counsel. And also next to her is Diane Dobbs, who's also Legal Counsel. To my right is Licensing Manager Anthony Sudato and Catherine Taylor. And to Ms. Taylor's right is Susan Morris, who's the Licensing Midwife Analyst. We're going to start off today. This meeting is specifically for the two regulation that we have in the packet. We are asking if you don't mind filling out a speaker slip for when you come up to speak so that we have your names down correctly. And also, we'd also sort of like to know how many people would like to speak on the first topic just by a show of hands.
The first one is
The first one will be on physician supervision and collaboration. All right, so, and how many would like to speak on the second one, which is the midwifery practice, the test drugs and devices? Okay.
Good morning, everybody. My name is Kurt Hepler. As you found out just a moment ago, I'm one of the battery of attorneys that are here today, so consider yourselves well represented. So before we begin, let me just take a moment or two and kind of set the ground rules if I could. Number one, this is an interested parties meeting, so that means what we're here to do is we're here, the board, through its staff, is here to act like little bitty, itty bitty sponges and suck up, if you will, what you have to say. So our purpose is, your purpose is to provide us with input and comments, and our obligation is to write them down, take notes, compile them, and then they'll be presented to both the back at a later date as well as the board. So having said that, again, as Mr. Warden pointed out, the object of this is to solicit input about the regulations that are clearly enumerated in your packet. This would be 2A and 2B. This is not a referendum on what the board did at its most recent action. It's not a referendum on whether the Cubs are finally going to win the World Series or not. It's really to solicit information about these two regulatory proposals. These two proposals were brought before the board at its most recent board meeting, and the board told us through its action, through its motion, to come back and have an interested parties meeting, and that's why we're here. It's really not a debate. It's not a cross-examination. It's not a running dialogue, essentially, of board actions or whatever. What we're here to do is take comments about the regulation such that I think this is a good idea. I don't think this is a good idea. I have a suggestion. I have a revision. I have an amendment. I have a total agreement with the person that what they said just in front of me. So that's the kind of thing we're looking for, because ultimately the goal is to take these comments back, distill them down, compile them, and hopefully go again through the process and be successful. So let me just say that's sort of the ground rules. Let me take one step back, and I have no knowledge of the medical field, but my colleague to the left has used the example before. If the law is the skeleton, and that's about the extent of my knowledge, the regulations are the flesh and blood, the sinew, the tendons, the ligaments that hold it all together. And the true purpose of a regulation, as specified in law, is to implement, interpret, and make specific statute. So that's the goal of these regulations. And as you comment on the regulations, I want you to advise you of one other thing, is that the medical board, and hence anything underneath the medical board, whenever it exercises its disciplinary, licensing, or administrative functions, consumer protection is its paramount goal. Okay? So with that, I think, Mr. Warden, I'll turn it back over to you, and we can start the process.
Okay, so in your packets that you have, we had some in the back, if you can bring them. We had Number A actually started on page 3, and that was sort of the background of the proposed reg. The actual regulations on page 5, and that's where we will start. So,
Well, I think what we'll do is we'll ask you to come up, and then if you just state your name so we can kind of have a clear record of who said what, so we can compile this in sort of an orderly fashion. And bring up your speaker slip, and if you wouldn't mind. So,
okay.
Carrie Sparrowbaum, I'm chair of the Midwifery Advisory Council, and I'm a licensed midwife. As most midwives and staff here understands, we've been working with this physician supervision requirement since the inception of our law and the initial licensing in 1996 and 97. It's a requirement that, as currently written, cannot be met. And so I am wholly in support of this regulation moving forward. I understand that it may not be perfect, and it may not even get us what we're hoping to get from it, but until we try it, we won't know. And I think that the paragraph B, which will establish that the physician that is collaborating is not in partnership or have a business relationship with the midwife he's consulting with, may open the door, and I assume we'll hear from the interested parties, which are the medical malpractice insurers, as to whether they think that will be helpful. But I think we need to make a change, and I'm hoping that this is the change that's going to create a field of safety for women who are choosing to birth out of hospital, and an atmosphere where the midwives that are caring for them can have access to information and advice that's out of their field of expertise. Thank you.
Thank you.
You ready for more?
Yes, we are.
and you are.
My name is Allison Osborne. I'm a licensed midwife in California, and I really appreciate and support the work people have done in writing the language in the proposed regulation. I know you guys are aware that in 1990 and 1991, when Senator Colley was working on writing this law, and she said, well, if supervision doesn't work, just change the language. And it's 21 years later, and we don't have new language, and I really like this language. And in 1999, when Judge Roman made a decision in the case that I was involved in, he differentiated between the midwifery and medical model of care, and he sort of defined the language the same way the language is in this proposed language, and said that it didn't work to not have physician supervision. I spoke with him to ask him if he would be an interested party today, and he said that as a Superior Court judge he can't make comment on what's proposed in front of the board now. But I just so support this language, and I think it'll work, and it's what has been working currently. Thank you.
Thank you.
Good morning. I'm Kathy Dowler. I'm the Associate Director of Research at the Center for the Health Professions at the University of California, San Francisco. And I'm commenting on the physician supervision requirement. I've been studying this issue for 20 plus years now, and I started when I was 7. And we've been looking at this issue nationally, and it continues to be an important issue for us and for many people across the country. Of course, we're particularly interested in issues of access for the people of California and the people across the United States. We need to expand and encourage all the numbers and the types of providers of healthcare within safe parameters because of the drivers of increased population, increasingly diverse population, looking for different choices, and most likely a significant increase in the number of insured in the coming years. We think that this regulation would go towards that to encourage the safe use and expanded use of more providers. We also are concerned with issues of safety. We want to encourage the medical board and California in general to get out ahead of the curve a little bit. We are tracking things like infection rates in hospitals and acute care settings where the trends are very disturbing, and it is quite possible that we need to look to other places, other settings for births to happen, because going into a hospital is now one of the leading causes of death in the United States. There's a high rate of infection. We're doing site visits at hospitals where they're saying they ran out of rooms for patients that need to be isolated last year, so they're concerned about the coming years. So we think that we just need to get a little bit ahead of the curve and consider what needs to be in place should we need to consider other settings and other types of providers generally. And finally, but most importantly, we are very concerned with the issue of interprofessional collaboration. The lack of interprofessional collaboration, sincere collaboration, is one of the most important breakdowns, the most important driver and breakdown in care. It's one of the systematic breakdowns in this country. We think that true, genuine, and sincere collaboration among and between professionals leads to better care. And this, the way the wording is phrased in this draft is better because it goes more towards that interprofessional collaboration and away from a supervisory arrangement between professionals. So thank you very much for your time. I'm open for questions if you have any.
All right, thank you.
Thank you.
Good morning. I'm Yvonne Chung with the California Medical Association. Thank you for holding this interested parties workshop today. We have several issues with the language as it's written, and I would point to certain, I'll just refer back to the actual language and our concerns. The first phrase in Section A that we have concerns about is the phrase informal collaborative relationship and what that means. We believe that this is really an unclear definition as to what that constitutes. It really leaves open the extent of a physician's responsibility for the patient. Our concerns are if there's a lack of clarity in protocol that could cause confusion on the part of the patient, especially if and when there are complications. It could cause issues resulting in delayed care at hospitals if it's unclear whether or not a patient is actually assigned to a physician when they are transferred. As I think one of the earlier speakers mentioned, we don't believe that this actually addresses the issue regarding liability carriers and the extent to which they may or may not want to insure physicians who supervise licensed midwives. And this language doesn't really seem to address that issue. And it also leaves open the question as to whether or not the extent of the physician's liability. We also have some concerns as to what this says about the physician-patient relationship. There are some patient abandonment issues here. If a midwife refers a patient to a physician, does that constitute a physician-patient relationship? We believe that this language here sort of muddies the waters a bit in terms of what the expectation from the patient will be, particularly if they go back and forth between the physician and the midwife. And what liability issues there could be for the physician if they fail to carry out an obligation that may be perceived on the part of the patient that the physician should be providing care. Let's see what else here.
Can I just stop you there for a second?
I'm sorry.
Just to make sure, because you can speak much faster than I can.
Oh, I'm sorry. I'll slow down.
So we have you mentioned a potential lack of clarity about informative collaborative relationship.
Right.
Whether this second issue is where this actually addresses the liability issue, C, the extent of